clock's on the screen.
Thank you, sir. Many years ago, when I was taking torts, my first year of law school, I was reminded by our professor that when considering punitive damages, only one word really needed to be remembered, and that was the word outrage. That word, it permeates the facts of this case, and we suggest requires this court on de novo review to reverse the trial court's determination that the plaintiff's proffer was insufficient to allow them to present a case of punitive damages to the jury. In this instance, there is really not a lot of Florida state decisional law establishing the standards for when a trucking company totally ignores all applicable federal regulations, which of course are embodied by Chapter 316 of the Florida statutes, does no inspections, does no maintenance, doesn't even pretend to do it, puts a dump truck with 614,000 miles on the road, with tires on the rear tandem that are so poor that steel belt is showing through them, and then wonders why a blowout occurs, which causes a collision with our client, causing a rollover. The vehicle rests in the median after 7 airbags deployed, one right next to Mr. Smith's ear. Thankfully, the airbag saved Mr. Smith's life. Unfortunately, the cost of that airbag deployment was Mr. Smith's hearing and his enjoyment of life. It is undisputed in this record that Mr. Smith suffers severe and worsening debilitating tinnitus, which he did not exhibit before this collision. He had some hearing deficits, but he did not have tinnitus. The defense presented the testimony of a CME examiner who examined him for over 4 hours and basically concurred with the testimony of the treating physician, Dr. Brink, that Mr. Smith had tinnitus, that it was worsening, and that it would not be helped by either masking agents or otherwise. Those issues primarily deal with the measure of damages, which we'll talk about in a few moments. I would like to again focus on where we believe the trial court got off the track in determining that no punitive damages proffer was sufficient. Of course, in this instance, the trial court is not supposed to adjudicate the matter. It's not decided as a summary judgment standard. The statute 768 specifically says that it should be considered in a light most favorable to the movement, that a proffer is sufficient. And
I know, but hasn't the case, Mr. Korn, but hasn't the case law said that the trial court also has to consider somewhat level the quality of the evidence? Because it says, reasonable showing of a reasonable basis for recovery. So it seems to me that the level, the quality, not only it's not like a motion to dismiss, where you can't consider the quality at all. Am I correct on that?
Well, the court does have a significant gatekeeper role here. That is true. But in this instance, the only defense that was really raised at the hearing on the motion to amend was the contention that these were mere inferences, that they were stacking of inferences, and that that they relied on the testimony of the corporate representative Howard, who said, "Oh well, we thought that front tire was just fine. The back tires were bad, and I got a price on some tires that I was going to replace them soon."
Was there evidence presented the condition of the tire? Was there expert opinion as to what the tire looked like before?
The tire that suffered the catastrophic blowout was so obliterated as a result of the event that it could not be meaningfully examined by a tire expert. But
what was the testimony as to the other tire, the other front tire?
There was no testimony as to the right front tire. The testimony specifically as to the right front. As to the other rear tandem tires, Officer Ragusa, who was the investigating officer whose testimony was proffered as part of the plaintiff's motion, said that in his 20-plus years of investigating collisions, he had never seen a worse set of tires. Had never seen a worse set of tires that were on the rear of that 614,000-mile dump truck that had been operated for 23 years with no inspections. I suppose, to your question, Judge Wolf, it's almost as if the defense seeks to be rewarded by their manifest lack of inspection and lack of duty. It's like the worse you got, the better they try to profit later, especially where on the before
Is
the
what differentiates this from any other blowout? Since we really don't have a testimony as to the condition of the tire, are you relying specifically on the inspections for the ability to go for punitive damages?
well, it's not just the lack of inspections. It was there was a lot of discussion below, Judge, about the issue of whether there was documentation appropriately maintained. The defense, in their answer brief, discusses at length the idea, well, mere paper violations is insufficient. These are not just mere paper violations. The type of regulations that we're talking about here are specifically designed and intended to promote safety of the vehicle and safety of the motoring public. This is not a situation, Judge, where the documentation about the driver's medical condition had nothing to do with the fact of whether he violated the right-of-way. That was one of the out-of-state cases that the defense relied upon. So in this instance, while we suggest that the whole corporate intent of this little Mike and Spike trucking company was to go out and make money as soon as possible and forget any regulations or any requirements, we don't even have to get there. It was the, again, remembering an old pre-comparative negligence concept, Mr. Padgett, the driver, we would suggest had the last clear chance to have avoided this whole tragic scenario. Rather than just his supposed testing with a hammer, if he had actually looked and saw that the tires on the rest of the vehicle were wholly unsafe and substandard.
Mr. Korn, I'd like you to discuss a little bit. You made an argument in your brief, and I want the other side to respond, that somehow the trial court used the wrong standard because this driver was also a partner in the business.
Right. Well, it seemed from looking at the order, Your Honor, although the Judge Cole, remember there were two judges in the case. Judge Cole handled the issue pertaining to the punitive damages. Judge Blas actually tried the case because of a divisional change while the case was pending. We suggest that one of the reasons that the judge erred in the analysis was being swayed by cases which focused more on vicarious liability issues rather than direct liability issues. In this instance,
do we know the judge actually used the wrong standard?
We suggest that the judge, in its consideration, and especially its reliance on some of the out-of-state cases, which were vicarious liability situations, does in fact implicate the erroneous standard.
Oh, one of your counts was for vicarious liability, was it not?
It was alleged, but you don't have to get there, Judge, precisely because both Padgett and Howard are owners of the business 50-50. So it's not just we're trying to get to the corporate owner because of the bad act of the employee. Here, Padgett, the operator of the vehicle at the time of the blowout and the collision, was a 50% owner of the business. And that is, I believe, a significant distinction because so many of the cases that the defense relied on below and in their brief deal with vicarious concepts, not direct liability. That would be the other part of the subsection 768.
If what differentiates this from any other blowout is the lack of inspections to even get into the vicarious liability of the driver, or are we talking about the negligence being the failure to inspect?
Your Honor, I would respectfully submit that it's both, really, because here we're not just saying that the failure to maintain a logbook or documentation was the direct causal relationship. This was not a situation, for instance, where the defense alleged, the emergency doctrine. They have, to the extent they ever asserted it, it was abandoned when they admitted liability. And by admitting liability here, what the jury ultimately saw was a very antiseptic view of what happened here, which we suggest also materially impacted the very low and we believe unreasonable measure of damages, which we suggest in issue 2 was against the manifest weight of the evidence.
Exactly what would have been sufficient damages, non-economic damages?
Well,
I always have problems with these non-economic damage cases.
Understood.
It's not enough. But what would have been enough?
Well, we would suggest that given the 16 factors that were laid out in the briefs about how Mr. Smith's life has been irreparably harmed and will get nothing but worse in his golden years, the amount of damages that were awarded, when you spread that over his life expectancy, we believe was low. Is there a number, Judge? I can't give you a specific number. Just like any advocate when arguing to the jury says, jurors, use your common sense and come up with a number that is fair. We respectfully submit that under these facts, these numbers, both as to the award to Mr. Smith and the very low consortium award to Mrs. Smith, do not bear any reasonable relationship either to the past non-economics or the future economics, and are manifest.
Did they have to believe the testimony of Mr. Smith, though? Wasn't that his credibility called in question?
Well, there was
About the time he wore the hearing aids, for instance?
There was some issue about what he did with his hearing aids, but the impact upon Mr. Smith's life after this collision was not ever materially rebutted. I know I'm into our rebuttal time. I'm happy to address the balance of your question if I haven't already. Otherwise, I'll reserve.
Thank you.
Thank you.
Fine. Thank you. Ms. Gonzalez, you may proceed whenever you're ready.
Good morning, Your Honors. May it please the Court, Lisa Gonzalez on behalf of the Appellees, Mr. Padgett and Mike and Spike Trucking. I am here with Alexandra Valdez as well. Your Honors, there was no error in the trial court's denial of the motion to amend and a punitive damages claim. As you mentioned, this is somewhat of a heightened standard where we have to keep in mind that a punitive damages is the exception. It's not the rule. Defendants have a substantive right not to be subject to punitive damages, and there's a high threshold showing that plaintiff must make in order to bring this claim.
Is there
and so while they don't,
is there any level of damage to a tire that's put on the road that can rise to the level of punitive damages? I mean, if the steel's showing and everything else, why shouldn't we subject people to punitive damages? Why shouldn't we stop them from going on the road with some really, really bad tires?
I agree with you, Your Honor. If we had a situation where we had this tire in terrible condition, and the Appellees, Mike and Spike, were aware of this, and they continued to drive this truck, then I do believe that would rise to the level of punitive damages, perhaps. But that isn't what we have here at all.
Okay, that's interesting. Having said that, don't we have to take the evidence in light most favorable to the plaintiff going for punitive damages? I mean, we check the quality of the evidence for sure. But once you're conceding that just riding on a bald tire can, in fact, ride to the level of punitive damages, how do we distinguish when you hit that point? Do you understand my question?
I believe I do, Your Honor. I think the distinguishing factor is that here, in this case, the accident was caused by a front tire that blew suddenly and in an unanticipated manner. There is no evidence that this front tire in particular was in bad condition, was with the treading exposed, or excuse me, maybe I'm not using the correct terms, but with regard to that tire in particular, which caused this accident, there is no evidence that tire was in bad condition.
Do we know anything about the condition of the other front tire? Because I mean, Mr. Korn makes the point, if there are three bad tires, it's kind of far-fetched to think that there was one good one and that was the one that blew up. In
various instances during their depositions, both Mr. Howard and Mr. Padgett were very clear that the front tires did not have a problem. Mr. Padgett also mentioned a routine DOT stop where they did a routine check and the tires were okayed. And he also explained why, because they did indicate that the back tires were not in the best shape. But they explained why the way that the way that the truck is set up, I guess, or the way it drives, why the rear tires would be in a poor condition and the front tires could still be good. And they, again, emphasized that various times throughout their depositions, the front tires were good. There was no problem with the front tires.
What about the trooper's testimony?
We're talking about Officer Ragasa. That is the deposition testimony that the appellant is relying on at this point during the proffer for the punitive damages. That particular officer, at the conclusion of his deposition, said he had no independent recollection of this accident. He said that he did not inspect at the scene. He had no firsthand knowledge. His opinion was based on photographs that were shown to him during his deposition. And we are of the opinion that that is not truly representative of the condition of these tires post-catastrophic accident. That cannot be representative of the condition these tires were in prior to that. So
do we know when the pictures were taken? Was there any testimony as to that?
These pictures were taken at the scene.
So immediately after the accident, the condition of the other front tire would not be relevant or pertinent.
I don't believe it's an accurate or fair representation of what they looked like prior to that accident. Because at this point, the car has been involved.
You mean 1 second before and maybe 10 minutes after, there was a big difference in the wear on the tires?
I think there could have been a difference.
There could have been. Does it make sense that there'd be a big difference a couple seconds before in the accident and right after?
I think there would be a difference. And again, I just want to reiterate that across the board, the testimony was that the front tires, all of them, were in good condition. So they couldn't have been so poor immediately following the accident either. But I just don't think that it's an accurate representation to show photos of post-accident car that has been involved in this catastrophic accident, and to use that as the condition that they may have been in prior to or that morning when they're inspecting this truck and deciding to take it out on the road. I don't think that is.
Was there any proffer by an expert or anything? And I'll ask Mr. Korn this as well. Besides the officer, concerning the condition of the front tire, the other front tire. I mean, I know there's a picture, and I know he said they're in bad shape. There was no expert testimony, though, with the other front tire.
I believe an expert was hired by the appellant to inspect the car, but the truck, and the tires, but I don't believe that they offered any of that into evidence.
Counsel, I've got a question about what the standard, the factual standard is for the trial court or for us to consider here. You know, you've got, sort of a dismissal standard where we have to accept the facts, we or the trial judge have to accept the facts as is. And then the other end, of course, is the judge weighing the evidence to determine whether it's convincing or not. Obviously, what you're telling us is that it's somewhere in between the two, that it's got to be reasonable. How is the trial judge supposed to apply that? How are we supposed to apply that? How much can we weigh the evidence to determine whether the punitive damages claim should be allowed?
Let me see if I can properly answer that. So I think that I think the evidence needs to at least point to facts or circumstances that rise to the level of intentional misconduct or gross negligence. So maybe you're not weighing the evidence for other purposes, but it needs to at least show you that here we have a base that is implicating something grossly negligent or malicious. And so he doesn't have to show all of the actual evidence, but we do need to point to these particular facts and look at them and say, does this amount to anything more than simple negligence, keeping in mind that a defendant has a substantive right not to be subject to these damages unless this showing is made. So it is a bit of a higher standard than your typical amendment standard, or what you would look at when you're going to consider allowing an amendment of other sorts.
How about this argument, because you really didn't specifically respond to it in your brief, about the standard of vicarious liability being looked at rather than the direct liability of the owners. Can you respond to that, please?
Yes. So we contend that the right standard was applied, but I think more importantly, under either standard, their showing is insufficient. So if the wrong subsection was applied below, which I believe is somewhat unclear, it would be harmless because the showing is insufficient under either subsection of the statute. So this court would still be able to affirm, even if perhaps for a slightly different reason, if that's the correct word. If your honors don't have any questions, I would like to briefly address the issues with these alleged violations of the FMCSA regulations. I want to note that the violations that he's alleging are regarding record-keeping inspections, manuals, and general checks of Mr. Padgett, the driver. I want to quickly note that this is a business that had only been around for 3 months at the time of the accident, and now that certainly does not excuse them, but it was a business that was in the startup phase, and there are various instances throughout the parties' depositions where it is clear that they were trying to comply. They were making perhaps makeshift efforts at complying during this startup phase, but they were making an attempt to do so. In terms of, makeshift record keeping, Mr. Padgett was conducting inspections before every drive. He was very experienced, so he knew basically what to look for, what not to look for. And there is no direct evidence, notwithstanding that, there is no direct evidence relating any of this poor maintenance or Mr. Padgett's driving to the cause of the accident. So a failure to comply with these regulations, which again, we would emphasize that they were making an attempt to do so during these first 3 months of their business, is insufficient without more to warrant a punitive damages award or to warrant bringing the claim.
You would agree, though, that notwithstanding you saying it's just a paper violation, the failure, if there was a failure to inspect the tires as required under federal law, that would have been the cause of the accident, right?
If there was a failure to inspect the tires, but there was not. We have evidence of the parties in their depositions both said that the tires were inspected routinely, constantly, before every trip, and including that morning. Mr. Padgett provided us during his deposition with a detail of what he inspected before every trip and including that morning. And again, we don't have any evidence that the front tires were in a poor condition. They still checked the tire, of course, but I just want to continue to emphasize that we didn't have any evidence in the record that these tires in particular were in a poor condition that morning when he got in that car and went out for to the work site. And just briefly, I've lost track of the timer. I can't see it on my screen, so I don't know how much time I have here.
You're down to 2.5 minutes.
I just wanted to briefly touch on the denial of the motion for new trial on the basis of the future non-economic damages. Very briefly, future non-economic damages are speculative. They're uncertain. There's no set standard for these. The jury was provided with ample evidence, much of which conflicted in one way or another. At the conclusion of the trial, the trial court denied directive verdict basically on this basis because there was conflicting evidence. The jury could go in either direction, so they declined a directive verdict at that time. And importantly, during closing, the parties provided suggested figures, and the award came in right about in the middle. So, the award was rationally related to the evidence. It bore a reasonable relationship to what was suggested at trial. There is just no facts or evidence to support a higher basis or a higher award for future non-economic damages. and for the same reason, Aditor was likewise inappropriate. And so I don't believe that they've advanced any basis warranting a new trial, or that the trial court abused its discretion in denying them a new trial. And simply in conclusion, Your Honor, Your Honors, this is a case of simple negligence. The Smiths have had their day in court. They have been awarded damages. There is nothing before this court at this time warranting a reversal or a new trial. So if the court has no further questions, we would rest on our briefs and respectfully ask this court to affirm.
Thank you, Ms. Gonzalez. Mr. Korn,
Thank you.
you have rebuttal?
Yes, yes, Your Honor, I do. Thank you. Let me address some of the counsel's points and your question that you wanted me to address, which was there an expert who looked at the other front tire, the right tire? The order actually said the right tire blew. Actually, the evidence all shows it was the left tire that blew, consistent with the sketches. The answer to your question, Judge, is no. One of the complicating factors, of course, is the dump truck was totaled and it was gone. And despite a spoliation notice that was sent by plaintiff's counsel to Mike and Spike, Mr. Howard decided he was getting out of the trucking business, so he got rid of all the photographs that had been taken other than the photos that were at the scene. Amazingly, a few days later, he had a change of heart after he got rid of all that material and went back into the trucking business by buying a new dump truck. So, yes, Your Honor, nobody could look at that other tire. We suggest one of the reasons was because of the specific actions of these defendants. The business was actually open 5 months, not 3 at the time of the collision. And I'm intrigued by counsel's comment that, well, they were trying hard. They were just a small group and, they were in their startup phase. The regulations don't make a distinction between small startup guys running a business out of their garage and Freightliner type operations. The regs are clear. At 693 of the record, all of this was part of the proffer. It talks about the condition that tires used on commercial motor vehicles must meet specific safety rules. No tire that is in use on a commercial motor vehicle may have any of the following defects: body ply or belt material exposed to the tread or sidewall. So I would suggest, Your Honor,
The violation of a regulation or statute is evidence of negligence normally. What specifically pulls this regulation into the punitive damage realm?
Because, Your Honor, whether we believe the self-serving testimony of the defendants that the front tire or tires were just fine, and again, that's not looking at the evidence in the light most favorable to the plaintiffs, it's a red herring because that vehicle should never have been on the road that morning, period. The condition of those rear tandem tires was so deficient, so unsafe, that they should have not waited until Mr. Howard got around to replacing those tires. They should have replaced those tires immediately. And counsel's acknowledgement that, well, if the principals had some knowledge of the dangerousness of the condition, then maybe punitive damages might be appropriate. That's exactly what happened here. These guys knew these tires were bad. That vehicle should never have been on the road to cause danger to the motoring public and the tinnitus and significant permanent injury to Mr. Smith and the consortium damages to his wife. So, we can try to parse left front, right front, rear front. The vehicle was dangerous. It was a hazard waiting to happen. It wasn't just geez, the tires were fine. I replaced them 3 months ago and it blew out because maybe I hit a nail. That's not what happened here. We had a conscious pattern. Even the Spaulding case, which is referred to by the defense, one of the Kentucky cases, talks about the fact that a course of conduct can be so outrageous, outrage again, that it subjects a party to punitive damages. In this instance, that's where the trial court got off the bridge. It's not just intoxication. It's not just profit motive, although profit was clearly at issue here. This order must be reversed and the case remanded for a new trial so the plaintiffs can seek punitive damages in front of a jury. Unless the court has any other questions, I will send all briefs.
Your time is run, and probably for the last time, I'm going to say, there being no further cases in front of the court will stand in recess. Thank you, counsel, for good arguments.
Thank you, Your Honor. If I might, I just want to say It has always been a pleasure appearing before Your Honor, and I wish you much happiness in your retirement.
Mr. Korn, let me ask you one other thing.
Yes,
Before
sir.
we sign off, we were trying to think, I know you clerked at this court. Who did you clerk for?
I clerked for Robert Smith in 1980 and into 1981.
Okay, thank you. I couldn't remember. Thank you
Yes,
very
sir.
much.
We were
No
still in
further-
the basement. We were still in the basement of the Supreme Court at that time. And so what I call now the old courthouse was to us still the soon to be new courthouse.
I shouldn't get into all this reminiscing, but the first time I went to meet my father-in-law was in the basement of the Supreme Court.
Absolutely. It was quite a place.
Okay.
Thank you, Your Honor.
Thank you very much for wonderful oral arguments. Court
Thank you,
stands
sir.
in recess.
Thank you, Your
Thank
Honor.
you, counsel.
Thank you.